Well, hello there, ladies and gents. Great to see you again. Welcome back to Closing Arguments. Ryan Ruff here, your moderator. Jack Razumich alongside me as always. We've got an interesting one for you guys here today. Today's topic, we're talking about the most difficult thing about being a criminal defense attorney. You know, a lot of people, they know what a criminal defense attorney does. We've watched the shows, we've seen the movies, we've talked to Jack. You're here, you're listening. So you know what he does. But today we're talking about something a little different, and then it's really the other side of the coin. It's what it's like to actually be one. Jack's gonna be peeling back the curtain a little bit into his experiences of mitigating criminal defense cases and arguing on behalf of his clients and working with the greater community here in the state of Indiana, and walk through some of the challenges that exist, but also some of the strategies that exist along the way as well. So before we get into all the good stuff, let's go ahead and say hi to Jack. Jack, good to see you today. How we doing?
Hey, Ryan. Exhausted as always, but still fighting the good fight.
Yes, indeed. Jack, I know you and your team, you guys have been hustling of late. But of course, we appreciate you being here on the show. Jack, the first theme that I think is a good place for us to start here today is expectations. That's a huge part of your world of talking with clients and managing those expectations when it comes to the process of fighting a case versus how everything plays out on the back end. So when someone does hire a criminal defense attorney, let's start here. What are the expectations that they often bring in? And then what are you finding that you need to spend a lot of time clearing up?
I would say the number one expectation that people have sometimes is that hiring a private criminal defense attorney is akin to hiring a genie. And that's unfortunately not true. I wish that I had magical superpowers or a Green Lantern ring to fix the problems of everyone that comes to us. But that's realistically not correct. And I think we talked about this in an earlier episode when we were talking about myths that people still have about the legal profession. The idea that if I just throw more money at this, it's going to go better. Spending more money is going to get the judge on my side. I'm going to get the best attorneys, et cetera, et cetera. Again, that's just not a true thing. When you're hiring a private attorney, you're hiring someone who is able to give you more time and better explanations and devote more resources to your defense. And those will sometimes result in better outcomes. I mean, having someone spend 5 hours on your case versus spending 1 hour on your case, you can be reasonably sure that the person who's spending 5 hours on your case is going to at least have made sure that every single thing that can be done has been looked at on your case. But it's not going to magically change the outcome just because you have a private attorney. Sometimes the hole that we're digging our clients out of is just too deep. We do our best within the structures that we have. But hiring a private attorney, that's the number one expectation that we typically have to have with people is we will do everything that we can for you, and we will make sure that you understand what is going on and why things are happening. But I can't snap my fingers and make this stuff go away. It just doesn't happen that way.
No, of course not. And you mentioned those instances where the hole is pretty deep and the facts are the facts, and it's not looking great for the client. So my next question for you is, when you have to have those difficult conversations, when the news isn't really what your client wants to hear, how do you go about that? How do you have those? What are you thinking about in your head as a way to convey that conversation?
Ideally, if we've done our job properly up to that point, the conversation's a lot easier because you build that trust, you build that rapport. You always hear the jokes about the doctors with their bedside manner. You don't want the doctor who just walks in 5 minutes after you have your x-rays, say, congratulations, you have cancer, get your will in order. That's not a good doctor. They'll ease up to that.
Yeah.
Same situation. We've talked about before, your average criminal case these days takes months from start to finish. I think that I talked at one point in time, on average, any of the felony cases that we work on, it's typically about 8-ish months before I'm comfortable telling my clients, okay, we have a resolution, or these are your options for resolution, including the all-important one of like, yes, we can absolutely go to trial and do something with this. That's 8 months of time and opportunity that we have to build that rapport and build that relationship with the people that we're helping. So we do have those conversations with people, and sometimes they go well and sometimes they go badly. I remember very early in my career, it was one of the more surreal things that I'd ever had happen. I had a guy who was, he was charged with a felony. He was charged with a forgery offense. It was a felony forgery offense. And, you know, we did everything that we could to minimize the damage that he was looking at. He had an extensive criminal history. He had a lot of things that were hanging over his head. And I remember going to the jail and, you know, telling him, I was like, I'm sorry, the best that we can do for you is going to be the Department of Corrections, and they want 5 years. You know, they're not going to ask for any probation after, so you'll do your time and you'll be done. But that's the best I can do. Like, I can't come up with something that's going to have less time. He actually shook my hand and thanked me because he was concerned that he was going to be getting a lot more time based off of his criminal history. So that was, again, a situation where we had the time. We were able to build that rapport over the months that we were representing him. And that conversation went very well. Other conversations we can't do much with. Like, no matter how much we try to build a rapport, again, some people will just kind of get in that situation of, this isn't fair and I'm not going to listen to it. On the flip side, we just wrapped up a case. It was a probation violation. Now, the facts of this case, just very, very briefly, my client was on probation. He violated his probation by testing positive for drugs. That's one of the number one things. There are 3 things you want to do on probation. 1, don't break the law. 2, show up if the probation officer tells you to. 3, don't test positive for drugs. So he broke number 3. Then he was a fugitive for 2 months before he got picked up for a felony driving offense. So he's now broken 2 of the major important rules of probation. We pick up his cases, and you know, we talk with him while he's incarcerated. We agree that he's not a good candidate for probation moving forward. He's had multiple opportunities. He was, by the time he picked up this felony driving offense, he was technically eligible to be a habitual offender. Like, they could have put him in prison for a very long time. But we worked with him, and on the driving offense, we got him a fully executed sentence that was less time than the state originally wanted. So again, like, we're mitigating the damages on this, and he's happy with that. And then we get to the probation situation, and we also get probation to agree to less time than they were initially wanting, and that's where this happiness stopped for him. Like, his concept was like, well, this is a low-level offense, this isn't that serious, it was just a driving thing. And again, like, it was just the fixation of the unfairness aspect of it. And despite the fact that we'd had a good relationship up to that point, and in 2 different cases we got him less time than what the state of Indiana wanted, we still turned out to be the bad guys on that one. So, like, there's never a good answer to that. The only thing that we can do on our end is, again, try to keep the people that we're working with aware of what's happening, why things are happening in the sequence they are, and just do our best to make sure that their questions are answered.
Yeah. Do you find that one of your biggest jobs is really just helping clients understand the process, and not just the law, but the process, what comes next, why this is what comes next, so on and so forth?
I would say that that's a pretty significant portion of the job, yeah. Again, going back to the stuff that we talked about plenty of times before, like, none of this is like it is on television. And I don't buy into the whole CSI effect that we used to have judges and prosecutors talk to juries all the time about, like, now, you know that we don't really have those cameras that can just zoom in and make it clear. As it turns out, thanks to the Flock system, apparently we do, but that's a completely different soapbox. But, you know, they'd have those conversations. They stopped doing them because the jurors were giving them feedback that they thought the judges and prosecutors were treating them like idiots because they knew the difference between television and reality. But you do still kind of have that, at least there's the expectation, like, this is the general framework for how these things are supposed to be going and how they're supposed to be doing. So I think that what happens is the client will find themselves, the people that we're helping find themselves in this world that makes no sense. Like, there's a lot of just completely ridiculous, seemingly contradictory things that happen in the law and they need it explained to them. Character evidence is a great example. We could probably do a future episode on that concept, but the number one thing that people will always ask is, I can bring you 10 people who will come and say that I would never do something like this. And it's like, okay, that's awesome that you know all these people who will testify you're a good character. That doesn't have a bearing on whether or not you snap this day. And it was not one of it was the first murder trial that I ever worked on. It was an elderly case. It was a dementia type of situation. It was very sad across the board. But my client, one day after years of happy marriage, picked up a candlestick and basically clubbed his wife over the head, killing her. And it was one of those things that was completely out of character. And like everyone's like, he's a good man. He would never do things like this. He didn't do anything like that up to that time. But all the good experiences does not necessarily mean that on the day in question for what you're charged with, you didn't snap. And that's one of the things we always have to explain, because everyone thinks like, well, I can just bring all these people in who will talk about what a good person I am, and the jury will see that these are all lies. That's one of those things that we have to explain, because that does seem contradictory.
It does. Well, I want to shift the conversation now to a little what I would imagine is a tricky spot for you, Jack, and you and your team as you work through these tough moments in these folks' lives. I think the general public views criminal defense as the process of arguing in court or arguing at that jury trial. But if you're a frequent listener to the show, you know we talked about jury trials and the frequency at which they happen, and we're seeing that number drastically moving down into plea agreements that get solved earlier. Jack, if that's not the case, your public perception's wrong, and the majority of your time isn't spent arguing in court, how much of your job is actually helping people just navigate the emotions around what they're up against?
There's a I wish I saved it, and I wish that we knew how to put memes up on the video feed for this, because there are these memes online about how, there's like a pie chart about, what I thought I would be doing as a lawyer, and 90% of it is like arguing in court, and then the next chart is like what I actually do as a lawyer, and like 90% of it is answering questions. And that's a fairly accurate breakdown. Most of the arguing that we're doing is with prosecutors. There are not a lot. We're seeing them increase a little bit. The discussions we've had earlier about the declining numbers of jury trials overall nationwide, that is still an accurate phenomenon. It is one of those things that nationwide, because of the spikes in the severity of charges and the concept of charge bargaining, the number of jury trials that are happening are declining. In certain sections, depending on the specific offense, we are starting to see those trickle back up, because there's not a lot of incentive to be reasonable if you work for the state. No one ever lost an election by being tough on crime. Like that's literally, we're in an election year right now. That's literally half the damn campaign ads is tough on crime, lock them up, all that stuff like that. So we spent a lot of time arguing with the prosecutors to try to get our clients into the best position that they possibly can be. Again, going back to the issue of we're trying to mitigate damages they've done to themselves. But a lot of it is just the navigation aspect of it, kind of explaining to them that, okay, if you take this option, these are the potential outcomes. If you go with this option, we go through, these are the other potential outcomes. One of the things that we do at our firm that is relatively unique, I think, to us, with our major felony cases, we will actually put together what we refer to as a case evaluation report for them. And it's a fairly comprehensive report. It's about 13, 14 pages, and it goes through, this is what you're charged with, this is what the state needs to actually prove, this is the evidence that's been exchanged, this is my analysis as the attorney that you've hired to help you navigate this, what I think of it. And we give them three options at the end, which is option one, You can take the plea agreement that's offered. Option 2, you can make an open admission to the court. And option 3, you can proceed to trial. And we basically kind of give them a breakdown on how all that stuff works. So it's a lot of explaining and helping them navigate that, because each of those options has a different outcome.
Oh, very much
with
so.
a plea agreement, with a plea agreement we talked about before, plea agreement, you always know exactly what's going to happen to you because it's written right there, black and white. If you go to a trial, there's a lot of variable on that because you don't know what's going to happen. You don't get to do a jury, decide you don't like the verdict, and ask to do another jury the next day. Like you're one and done. Like you are stuck with that decision at that point. So explaining those collateral consequences, like that is a big part of this job and part of the relationship building that we have with the clients.
It makes all the sense in the world. But Jack, to not force you to, but to have you peel the curtain back a little bit, how do you personally navigate and balance the empathy with professionalism when you're dealing with clients that are scared or angry or just highly emotional? How do you walk that tightrope?
As carefully as we can. They've done psychological studies on these things, and they find that if you have a group of people who are lost or unsure or kind of scared, the first person who stands up and says, "Follow me, I know what to do," automatically just becomes the leader. Like, and it's not a universal thing, but like if someone says water is this way, and they say it with like a calm authority, like they know what they're talking about, people are like, all right, well, this guy seems to know what he's doing. We'll follow him and see if we can get water. The practice of law is very similar. We are dealing with scared, lost people who need someone to tell them what's going to happen. And
someone who's grounded.
Yeah, you want that person who's going to say, follow me, I know what to do. Mm-hmm. That gets a lot further than being too emotionally invested in it. And I don't want to make it sound like myself or any other defense attorneys are just completely callous. Like, we do care. Like, you can't do this job and deal with people who are having the literal worst time of their lives without some sympathy for it. Like, you just want to be effective at this job. But that's got to be tempered. I mean, it does. The reason that doctors aren't allowed to operate on people they know is because they lose their objectivity. Like, they don't, if their kid or their parent is on that operating table, they may try, they may try harder to save them, but eventually there's the risk that they're going to try to do things that otherwise they wouldn't do for any other patient because they know that it's not appropriate. Same thing with being an attorney. We will try as hard as we can for all of our cases, but you don't want to become so emotionally invested in the case that you lose your objectivity.
Right.
There are hard conversations that we have to have with those clients. There's some of those case evaluation reports that I talked about. I have sat down with people and watched them go through the multiple stages of grief right in front of me as I am explaining to them, this is as good as it gets. My professional advice is that you take this plea agreement that we know will send you to prison for 2 decades, because if you proceed to trial and you lose, which based off of my analysis is a more likely than not probability, you will die in prison. Like, you have to have those conversations, and you need to be able to maintain that objectivity, because if you can't do that, then you're not doing your clients any favors at that point in time. You're basically, I'm not your parent. Like, I am the professional you have hired to navigate you through these things. Like, I will care about you. I will make sure your questions are answered. But at the end of the day, you have to be able to step back and say, I didn't shoot up a liquor store. I mean, it's like, it's crass to say it that way, but like, at the end of the day, I didn't put myself in that position. I'm going to go home to 2 wrecking ball dogs that are going to take me out at the knees when I come back, because I didn't put myself in that position. Doesn't mean that I don't care about the person who did put themselves in that position, but I do. All the best defense attorneys will maintain that slight detachment so that they can look at this situation objectively.
Sure.
Because that's what needs to happen to get the best outcomes.
Yeah, absolutely. Not only for the best outcomes, but also for Jack, probably your own sanity. And my next question, this is a good segue into it, is there's got to be some cases that have stayed with you over these years. What so on some of those that linger in the back of your mind after time elapses, what makes some of those cases hard to leave behind?
There are there are three categories of cases that stick with you. The first category of cases are just the ridiculously absurd ones. The ones where the facts of it are just so outright insane that you just remember them, and they're like blowing off steam memories. We worked on a prostitution case several years back, and it was a legitimate prostitution case. They were actually on the street doing their job, as opposed to just putting up an ad on Backpage, and just waiting for lonely guys to call a telephone number on the internet. They were actually out there, and this undercover officer picked up a female prostitute. And he had another undercover officer in the car with him, and they were going back and forth, and the conversation turned to the undercover officer number one said, will you do anal? My buddy here is into butt stuff. And she, the prostitute, and this is all in the probable cause affidavit. Like, the prostitute says, normally it's going to be 30 because it's too, it hurts back there. Let me see what he's got. So undercover officer number two takes his pants off, and she looks like, oh, I can do him for 20. So, she's cutting down. She's literally insulting his manhood by saying that he doesn't need to pay as much because he isn't going to hurt her backside. That stayed with me because it's insane and hilarious.
Oh, my gosh.
Other cases, there are some horrific stuff that you do see. I've seen autopsy photos of people who were very badly ripped apart by bullets or knife wounds. Some of that stuff does stick with you on the concept of, you can't look at it's one thing, when it's a horror movie. Jason Voorhees or Freddy Krueger, they're characters, they're imaginary, they're not actually killing anyone. When someone explodes on a movie screen, after the director yelled cut, they wiped the Caro syrup off of themselves and they went on with their lives. Real life's not like that. Some of the pictures I've seen, these people, they're never coming back, and that does stick with you sometimes. I think it is one of those things that's a little bit hard to kind of get away from that. I know that a lot of prosecutors have that problem, where the stuff that they see is just really heart-wrenching. You probably have to ask them how they deal with it. My suspicion is a lot of us have varied and unhealthy coping mechanisms on both sides on that, but that's what you have to do with it. And then the third category of the cases are the ones where you feel like there should have been more that you did. And fortunately, there are not a lot of those. There are not very many situations in the 2 decades that I've been doing this where I thought that we didn't do enough. The one case that really does stand out for me is we had an attempted murder case. Oh gosh, probably closing in on about 10 years ago. We had an attempted murder case, and the facts of it were the decedent had a long history of violent outbursts towards his wife. And when I say violent outbursts, I mean really violent, like beating her, threatening her and their kid with weapons. Not a good guy. And he had some mental health issues, and that's an explanation. It's not an excuse, but it's part of the background on that. The defendant in that case was the younger brother of the victim's wife. And when I say younger brother, like everyone is an adult here. Like it's a younger adult. Like we're not talking about kids or anything like that. We're talking about 30, 40-year-old people. The brother, the defendant, was at home. He was staying with his sister temporarily because he had recently been discharged from the military. He was staying there while he got set up. He was working as a security guard. And while he's there, a fight breaks out between the decedent and his wife, the defendant's older sister. And the victim he grabbed something and made what everyone agreed was a lunging motion towards my client's sister. And my client, who just happened to be armed because he was working as a security guard at the time, went in reaction, drew his gun, shot him. It was one shot, just hit him straight, square center mass, and the guy died. And they charged him with attempted murder, and we had a 4-day trial on that one. And like there weren't even a lot of witnesses. Like the deliberations took a good 18 hours almost by the time we got to that one. And they came back with guilty. And that's one of them that stuck with me because that one, morally and factually, he felt not guilty. It felt like he was defending his sister, but the jury disagreed with it, and I can't fix that. And that's one of them that's always stuck with me again for that same reason. It's like the cases where you think that there should have been more that you could have done, those stick with you, I think, harder than the other two.
Yeah, especially when the moral aspect of that case in particular comes into play. Yeah, that's a tough one, Jack. I appreciate you kind of peeling back the curtain, like I said, and giving us some insight into, how it is that you perceive these cases and navigate them and work through them. I want to shift now kind of to our third and final theme of the episode, and that is where you and your team are tasked really with defending somebody who you believe is guilty. But it's part of the job. You have to defend them. I know this is probably a question you might get often, but how do you guys approach it, operate, do your job when somebody that you are representing is guilty?
It's definitely not easy, and I will say, especially when I meet new people at social gatherings, which is one of several reasons why I don't go to social gatherings. After they find out what I do, that's somewhere within the first 3 to 5 questions that we ask. It's like, what do you do if you see the situation? And there's a late 19th, early 20th century lawyer by the name of Clarence Darrow, very famous guy. He represented the Leopold and Loeb defendants back in Chicago at the turn of the century. Basically, he was like the F. Lee Bailey or the Johnny Cochran of his day, like the guy that got the press, the guy that got the quotes. And his quote on the concept of being a criminal defense attorney is, "To be an effective criminal defense counsel, an attorney must be prepared to be demanding, outrageous, irreverent, blasphemous, a rogue, a renegade, and a hated, isolated, and lonely person, because nobody loves a spokesman for the despised and the damned." Which is true, but they still need a spokesman. The way that I typically explain it to people is to function as a society, we all agreed that we're going to abide by a certain set of rules. And those rules are this various statutes. In Indiana, it's Title 35, the criminal code. There are other rules that we have to live by in Indiana too. But for my purposes, these are the rules. These are the things that we have agreed are not okay. If you don't like that they're not okay, you can run for office and do something about it, or you can lobby the existing politicians and do something about it. Trust me, I get a legislative update every July that tells me about all the new ways that they've decided to screw my clients over because someone didn't like that something wasn't illegal or wasn't illegal enough. So these are the rules that we all agree to play by. Underneath those statutes, you have administrative rules that the courts have set up. And those are obviously a lot harder to change if you're not working in the legal system for obvious reasons. You're not going to be able John Smith, who works as a mechanic, is probably not going to be able to lobby the Chief Justice of Indiana to change a procedural rule that discusses how evidence can be presented. But again, like the people who are in that system kind of have that ability. We talk about the procedural rules. There are entire committees at the Supreme Court that discuss those things. And then kind of parallel to that, you have the rules of evidence that basically say, okay, this is how this type of thing will be treated. Character evidence is a great example of that. Character evidence is under Indiana Rule of Evidence 404A. Character evidence is not admissible to prove or disprove effect. Like, it's literally right there in the rules of evidence. So we can't do that. Those are the rules that we agree to play by. And overwhelmingly, those rules are not actually written with much input from the defense community. Some of the evidentiary rules, some of the procedural rules, those will get defense bar input on it. But overwhelmingly, this is all the state. So the state of Indiana writes the statutes. The state of Indiana writes the rules of procedure for the court. The state of Indiana writes the rules of evidence for how things are presented to the court. And then the state of Indiana has decided to charge you, the defendant, with violating these rules. From my perspective, if the state of Indiana cannot play by the rules that they themselves have written, then they don't get to win. It's simply that fundamental. You don't get to start playing a board game and then have one person say, I'm changing the rules right now, and the rest of you have to deal with it. Like, that's not how this works. And it's a similar situation here. For as much hell as I give the various prosecutors' offices and the various police agencies, more often than not, they do perform their job duties correctly. Could they do them better, in my opinion? Sure. Are there discretions that they could be exercising that they're not? Absolutely. But for the most part, they're not doing their job incorrectly. And what we do as the spokespeople for the despised and the damned is we're just basically going down the checklist. We get questions, I have people every case, like, they didn't read me my Miranda rights. And I'm like, okay, well, let me look at your case. Okay, this is how you were stopped. These are the questions that were asked of you. These are the questions that require Miranda. Here's the Miranda trigger point. And here's everything that you said before Miranda even became an issue by personally volunteering that, you had drugs in your car before you were even asked. It's like, you don't get to blurt out, I got drugs in my car after you get pulled over for speeding and then say the police didn't read me my Miranda rights. Like, you have volunteered a statement before there was an issue there on that. So we go through that checklist. We look at those things. We make sure has everything been done. And in some cases, they aren't. We have a case right now. Unfortunately, the Court of Appeals denied our attempt at line jumping it, which is unfortunate. But we have a case right now in southern Indiana that involves a guy who fell asleep in his car. The car's turned off. Like, this is even a situation like the engine's running. You can make an argument it's operating. He just falls asleep in his car, pulls perfectly into a parking space. Half the city police department shows up. This is a relatively small community. And during the time that they've got him there, they're going backwards and forwards trying to get him to give them permission to search his car, and he keeps refusing it. They finally get a dog out there. And to be fair, I don't think that they brought this dog out there. I think the dog was going to show up anyway because, again, like I said, half the police department showed up. Like, apparently, like, the standard operating procedure is, like, there are 10 cops on the force, and, like, anytime something happens, 5 of them will show up because, like, there's nothing else to do in that town.
Sure.
So I don't think that they held him for the dog to show up. I think the dog was always just going to show up because that's just the way things go with that. Dog does an open air sniff. They say, okay, we now have probable cause to search your vehicle with your permission or not, so put your hands behind your back. We're arguing, we lost the suppression argument on that one at the trial level. We tried to do what's referred to as an interlocutory appeal, which is where we try to tell the Court of Appeals, hey, if you decide this now, we don't have to actually do a trial. They unfortunately said no, which is their right. You have an appeal of right after a case is done. Interlocutory is a permission situation. So we'll go back. Like that case will probably go to trial. Like there are limited circumstances where I can see that case not proceeding to trial, just based off of the nature of the charge and the personalities that are involved in it. But that's one of them that, again, like there's no question about that. Like clearly he had plenty of drugs in his car. But you don't want to create a situation where you have created this atmosphere where, like, okay, well, I'm okay with the cops searching me anytime they want or holding me for any reason because every great once in a while they'll get someone who has drugs off of the streets. Like, that's not what you want. Like, if you want an authoritarian dictatorship, there are plenty of other places that you can move to. For right now, at least, we still have some degree of freedom in this country, and I personally would like to keep it that way. And that's what we're doing in this. Like, we're not fighting to make the streets less safe. We're not, my job is not to go out there and intentionally decide to put the worst people on the planet back on the street to menace you. My job is to make sure that everyone else is doing their job because, I don't want to have a situation where papers, please becomes the norm. And that's all there is to it.
Yeah, Jack, that's a really well thought out answer. I can tell, after 2 decades of doing this, you've got a great answer for when somebody hits you with the inevitable question of, how does it make you feel defending the bad guy? I think playing the, rules master, if you will, of the game that is the law, and holding the, the state accountable to operate within the confines of the rules that they have written for the game. It's a very understandable way of looking at that. So I appreciate that. That's really helpful to get your context. And I'm sure there's a lot of our audience out here who hasn't maybe necessarily thought of the role of a criminal defense attorney in that light. So thank you for that. So Jack, as we're kind of wrapping up here then today in closing, after everything that you've seen throughout your career, the cases you've worked on, the people you've been experiencing, what about being a criminal defense attorney what have you learned about people as a whole? I know that might be a deep dive, but is there any surface level nugget that you could pull away from just human behavior or people that you've learned from your time?
What I have learned about people as a whole is that most of us have extremely poor impulse control. I think is probably the best way of phrasing it. Now, again, that's going to be very heavily slanted by the type of work that I do. Nearly everyone that I come into contact with has impulse control issues. Otherwise, they probably would not have put themselves into the position where they had to come to my office and ask for help on that. That doesn't make them bad people. There are a lot of people who I have worked with that it might surprise some of the listening public, especially any politicians or people who champion the hang 'em high, lock 'em up crowd. Most people do feel bad for what they have done. There have been people that I have worked with that were full of piss and vinegar and made it very clear that they had no remorse and that they would do it again, and they do it right here in this courtroom if they had the opportunity. Most people that I've worked with aren't like that. Most people, no matter what it is, whether it was a complicated theft, a simple theft, even violent offenses, like burglaries and beatings, they feel bad about it. Like, does that make it okay that they did it? No, absolutely not. Clearly not. But the caricature that I think that a lot of people have about these hardened criminals that just don't care. There was the old Super Predator line from the 1990s. I remember that when I was younger. that doesn't really seem to match reality in my experience. Like, yeah, are there some? Sure, there are absolutely some that are terrible people that, them being shackled in front of me still doesn't make me feel particularly safe. Most of them, though, they know what they did was wrong. They accept what they did was wrong. They're sorry for it. Like, they are genuinely sorry. Um, it doesn't change the past, and they understand that. And I am sorry to say that we don't always do a really good job at letting them move on from that. But they do feel bad. Like, they are people that are still capable of remorse, and I think that most of them do have it.
That's interesting to hear, and I can imagine, especially when you had said it yourself, Jack. These people are going through some of the worst moments in their life, and I'm sure there's a level of vulnerability that and just pure sadness that comes through during those moments. And again, not saying that the actions that they did were correct in any way, shape, or form, but I guess it's encouraging to hear that there's still that human element that exists within them, despite what they had done. So, Jack, this has been a great conversation today. Getting the full picture of what goes on in that brain of yours and the brain of many criminal defense attorneys that have this difficult task day in and day out to represent folks, to fight the state, to ensure the state's playing the game the way they drew the game up. Jack, I know this conversation is probably going to get so much attention from our audience because it's a different one that we've typically had. If you had to leave our audience with one extra thought about, the next time they might need to hire a criminal defense attorney, what would be your final parting words?
The line between those people and you is nowhere near as thick as you think it is. Just kind of be kind, be understanding, understand that there but for the grace of God, you'd be sitting across from me too. So just always kind of keep that in mind. If you do find yourself needing to be seated across from me, we're happy to listen to you. We won't even call you despise you're damned. We'll let everyone else do that and kind of be your shield on it. But we are here to help. Again, as always, the best way to reach our office, our main switchboard number is area code 317-983-5333. That number is answered by live human operators 24 hours a day, 7 days a week. You will never get a computer answering your phone at this office. That is one of the few lines I am absolutely drawing a line in the sand on. That's my cultural contribution right now, is we will not have AI at this office. You have live people who are going to listen to you. Make sure that you're understood. Make sure that all that stuff we talked about understanding the process, what goes on, that you do understand those things with this office.
It's great to hear. And thanks for sharing that, Jack. Folks, we have that number there at the bottom of the screen. So should you need that help, you know where to find it. Jack, I appreciate you as always. We'll see you back here on the next episode. And I know you got clients to serve, so we'll let you get back to it.
Absolutely. Thanks for having me.
Of course. And look, folks, we're going to take a final moment, as we always do, and thank you for making us a part of your day. If you enjoyed today's discussion, if you learned a thing or two, I know I did, make sure you hit that subscribe button then on whichever platform that you checked us out on today, so that you don't miss out on future conversations where we sit down with Jack and maybe dive into some case studies or nuanced parts of the criminal defense world and bring value to you and yours. So for Jack, I'm Ryan. We want to go ahead and say so long, but we appreciate each and every one of you stopping by and being with us today on Closing Arguments.